Good afternoon, everyone. My name is Lisa E, and I'm the chair of LGR South of OCAR today, this year. Today, I have my LGR North chair, Matt Cortez, with us and joining to offer you this information session. Matt, you want to say something?
Just want to thank everyone for attending today. We always love to provide you with some great information, and hopefully you'll take some value with this and be able to share that with your clients and family.
Just want to remind everybody that this meeting will be recorded, and let's welcome our presenter, Robert Bloom. He is our CAR legal counsel. He joined the CAR in 2004, and he divided his time between writing articles for our CR magazine and also on the legal hotline. So I'm very happy to have him to explain about Prop 19 with us today. So Robert, I'm handing it over to you.
All right. Okay, so the first thing I need to do is share my screen, right?
Yes.
Okay, so let's do that. And can you see my screen?
Yes.
Okay, great. So how's everyone doing? My name is Robert Bloom. I'm a senior counsel with CAR, and I'm here to talk about Prop 19, but also the just cause eviction issues and the state rental assistance. And on a personal note, I am from Orange County. Los Alamitos, yes, Los Al High, go Griffins, yay. So exciting stuff. But first, before I get started, I want to give this legal disclaimer. So I'm not an estate planning or tax expert. A lot of the parent-child transfer and estate planning issues are beyond the scope of this presentation. It's really a highly specialized area. So anyone who needs that kind of advice, your clients must speak with a tax or estate planning specialist. So that's the disclaimer. And I think we can, I can go now. Okay, so Prop 19, what does it do? So it's actually a pretty straightforward law. It takes the existing system, which allows tax portability within all counties or even between certain counties. It takes this existing system and extends it. So under Prop 19, a homeowner who's 55 or over or severely disabled or whose home was destroyed by fire, they can transfer the taxable value of their primary residence to a replacement primary residence anywhere in the state, regardless of the location, regardless of the value of the replacement primary residence, even if it's of greater value, but there will be an upward adjustment if it is greater. They can do that within 2 years of the sale of the original primary residence, and that's 2 years before the sale or 2 years after the sale. And they can do this up to 3 times, and if the house was destroyed by fire, they can do it even more. And this applies on or after April 1st, 2021, and you see there's a little asterisk there, so I'm going to discuss what that date actually means a little later. So that's the black letter law. And this black letter law, Prop 19, is an improvement on the current system. And under the current system, you're allowed only a one-time transfer. It has to be within the county or only in certain counties that permit it. Now, which counties permit it? So you're looking at, in the box, the counties, the 10 counties which permit it, and Orange County is one of them. And apparently all of the surrounding counties to Orange County also permit it. So transferring across counties is not such a huge issue in Orange County. But you know, if the clients are selling and moving somewhere else outside of these 10 counties, then it's going to be a big deal. So that's the current system, but only if the value of the replacement property is equal to or less than the current one. So that's a big a big problem, that equal to or less. And on the next slide here, I lay out the advantages of Prop 19 over the existing rules. So first off, Prop 19 allows this property tax portability anywhere in the state. It's no longer limited to within the same county or between certain counties. Prop 19 also allows this property tax portability even if the replacement property is of greater value. So it doesn't have to be equal or lesser. And that's a major point of frustration oftentimes. And lastly, Prop 19, you can transfer the tax basis up to 3 times. It's not just a one-time thing. Okay, so those are really the big advantages, and especially in Orange County, this greater than thing is going to be very important. But realizing if the replacement property is greater than, then there is going to be that upward adjustment in the tax basis. And here I have the same sort of rules that I've been talking about in the form of a chart. It's just there as reference. That's all it's there for. Some people like the chart. It's easier to see and understand. Okay, so one of the big questions we've been getting is this April 1st deadline. So Prop 19 is effective April 1st. And the question really is, well, what happens if you buy or sell the property before April 1st? And so we're looking at these 3 scenarios. And the first scenario is the easiest one. And it's if both the sale of the old, I guess the original, if both the sale of the original principal residence and the purchase of the replacement principal residence closes on or after April 1st, 2021, then the Prop 19 rules clearly apply. And well, we only have 3 more days. So in 3 more days, everything is going to fall into this category. Okay, but just going through these scenarios, if both of the sale of the original and the purchase replacement occur prior to April 1st, then you're using the Prop 60, Prop 90 rules, the quote unquote current rules that I just discussed. And finally, you have this kind of between scenario where the sale or purchase takes place prior to April 1st, but then the subsequent sale or purchase happens on or after April 1st. And what happens there, it's not clear. However, if you have a client that wants to do that, they probably can do it, but you'll refer them to the Board of Equalization FAQ. The Chief Counsel for the Board of Equalization has written an opinion on this matter and has weighed in saying, yeah, we think you can do it. So you'd refer them to this Board of Equalization Q&A, and just to let you know, they have this very lengthy disclaimer, just in case anything goes wrong, I guess, I don't know. But anyway, that's only going to be the case for three more days, and I think this is perhaps the last time I'm going to have these 4 slides in my presentation. Anyway, so we're going to look at this question of equal or lesser value, because it's actually a little bit confusing on this point. So basically, under the current rules, you can sell your property and qualify for the transfer of the tax basis to a new principal residence when that new principal residence is of, quote, equal or lesser value. And that has a particular meaning under the current set of rules. Under the current set of rules, it means properties purchased at 105% of the purchase price if purchased within 1 year, or up to 110% of the purchase price if purchased within the 2nd year after sale of the original property. So that's what it means presently, and the issue really is, will that same meaning hold under Prop 19? So under Prop 19, is purchasing an equal or lesser property going to have the same definition of 105% of 1 year, 110% of 2 years? And the answer is, we don't really know. People hate that answer. It's a dissatisfying answer. But honestly, that is the answer at this point. There's sort of a tussle going on between CAR, our legislative wing up in Sacramento, and the Board of Equalization. So they want equal or lesser to mean sort of the plain English meaning, which means if it's the actual equal or lesser, then that's going to be the definition. But we want to rely on the existing definition. And obviously, I mean, we think that there's no reason why we shouldn't rely on the existing definition, because when they passed Prop 19, why would they have thought any other definition would apply? That's my argument. They wouldn't. Simple. Anyway, we don't really know what it means right now, but it will be clarified in what we call implementing legislation. So whenever they pass these types of propositions involving complicated tax scenarios, they have implementing legislation. Frankly, because taxes are so complicated, you have to have these kind of very lengthy legislative enactments to clarify everything. Now, when will that implementing legislation pass? Don't know. It's a very dicey business speculating as to when any item of legislation will pass. So not going to say. Okay, so here we are. You have a property. Let's say it's going to be eligible for the Prop 19 tax benefit. And the question then is, well, how much is the new taxable value? How do you determine the tax basis of the new property? And we'll start with, I have two rules here. We'll start with rule 1. So rule 1 is simple. If the replacement property is of equal or lesser value, and when I say value, that means, quote, full cash value. So if the replacement property is equal or lesser value to the original primary residence, then the taxable value of the replacement property simply remains the same as the original primary residence. It just simply transfers. So that's pretty straightforward. Rule two is where you get into a little bit of complication. So under rule 2, you're purchasing a property that's of greater value, whatever that means. So if the replacement property is of greater value than the taxable value of the replacement property, then there's an adjustment. And the adjustment is basically what you're doing is you're taking the difference between the sales price of the original and replacement property, and you're adding that difference to the current original taxable value, right? So difference between purchase price added to the current taxable value. And I have an example which shows how this works. So suppose you have an original primary residence with a tax basis of $400,000, and suppose it sells for $900,000. But the replacement primary residence is $1 million in value. So that's greater, obviously, than $900,000. So just to go back, under Prop 60, if you did this right now, you'd be out of luck. You basically would not be able to transfer the tax basis. But now you can, you just have to make an adjustment. So the new tax basis is going to be the $400,000 plus the difference between the replacement and the original. That's a difference of $100,000. And obviously that equals $500,000. $500,000 is the new tax basis. So that's a big advantage with Prop 19. Before, you couldn't transfer the property, right? You're just out of, well, you couldn't transfer the tax basis. That's what I meant to say. You're just out of luck, right? But now the advice to the client is really go and find something you want. Buy the property you really like. And they don't have to worry so much about this, whether they're going to transfer the tax basis. Mind you, there's that adjustment upwards if they're buying a property of greater value. Okay, so this all has to do with portability. So everything I've been talking about so far is portability. It's really sort of what we're interested in anyway. The idea of a person keeping their tax basis when they buy and sell their own property. And so the next two slides are about transfers to children and grandchildren. So it's a sort of a different part of Prop 19. So, so this is the intergenerational portion of Prop 19. Now, previously, all transfers of a principal residence to your children, and I'm just going to say children, I'm not going to say children and grandchildren. So previously, all transfers of a principal residence to your children were exempt regardless of how the children used the property, right? The child could rent it out, they could live in it. It didn't matter. Okay, and this principal residence exemption was unlimited. So $5 million, $10 million, it doesn't matter what the value of that principal transferred residence was. You simply got to transfer the tax basis, okay? And in addition to this unlimited exemption for transfer of the principal residence, the law allowed an exemption for all other real property up to $1 million. So these are fairly generous tax benefits. And I know, and just to let you know, if you're already enjoying the benefit of these reduced tax basis under these old rules, you're going to be grandfathered in. You are grandfathered in. It's not 100% clear that you're grandfathered in. I have seen, however, no proposal from anybody claiming that somehow it's retroactively applied. So almost certainly you're grandfathered in. So we're just talking about transfers which happened on or after February 16th. Okay, so under the new rules, so what's happening under the new rules? These are the Prop 19 rules. So under the new rules, basically, if you transfer the principal residence to the child has to continue to live in the home as a family home, as a principal residence. Okay, so you have to continue. Before you didn't have to live in it, now you do. There's another exemption for family farms, but I'm not going to talk about that, but that's in there. So a property that's transferred from parent to child, where the child continues to live in the in the home as a principal residence, and that person claims the homeowner's exemption within 1 year. So that's the new rule. Now, what about the exemption for all other property up to $1 million in value? What about that? Okay, that's gone. So that benefit is no longer to be had. So you just have the principal residence exemption, and that's it. Okay, but to tell you the truth, you don't actually have even that completely. So this is our last slide. Well, not exactly the last slide, but it's sort of the last substantive slide dealing with Prop 19. And it asks the question, how much will the new taxable value be? So assuming assuming the child gets the principal residence of their parent, then continues to use the property as their family home, then the general rule, which is the first thing I have up there, the general rule is that the tax basis remains the same. That's the general rule. However, there is an exception. And the exception has to do with how much higher the value of the property is above the tax basis. So if the value of the property is too far above the current tax basis, then the tax basis can go up. Okay, so even if you're using it as a principal residence, it can go up. So how much is too far above the original tax basis? That's $1 million. If the value of the property is $1 million over the current taxable basis, that tax basis, the new tax basis, will rise. So the new tax basis is going to be the value of the new property minus $1 million. So I know that's confusing, but that's why I have this example. So assume the assessed value of the family home is $2 million but the original taxable value is only 500,000. Okay, and that's quite a gap. It's 1.5 million. In fact, it's more than $1 million. Therefore, the taxable basis will rise. Okay, the new taxable basis will be $1 million subtracted from $2 million. So therefore, it's $1 million. I'll just come up with it. That's a complicated example. I'll just give you an easier one. Let's say the value of the property is $10 million. That's the new value of the property, the assessed value on transfer. But let's say the tax basis is much, much lower. Let's say it's $3 million. So you're looking at a property which is way, way, way above the original taxable basis. What is the new taxable basis? It's just $1 million minus its new assessed value. So if its new assessed value is $10 million, the taxable basis, the new taxable basis will be $9 million. Okay, so another way to think about this is instead of going through these calculations like I've just done, you can just think about it as you get $1 million off the current assessed value of the property, but obviously the tax basis will never be lower than the original tax basis. So that's probably an easier way to understand this, I think. Well, it's certainly a simpler way. Anyway, okay, so, and I have a chart here just as a reference, again, because people like charts and it's easier to understand these things. So a couple little tricky questions, which I'm gonna try to answer. One of the questions we get on the intergenerational question is, do all the children have to use the residence as the primary residence? And the answer I gave for the longest time was, well, I hope not. That seems ridiculous. You all have to move into the same property. So the chief counsel of the Board of Equalization has also weighed in on this question. And according to this guy, he says, no. I mean, come on. It's just, they're not going to write the implementing legislation to require that. And another big question we get, how long does the child have to remain in the property and use it as a principal residence, right? Is it like that 1031 exchange thing where you just have to, live in the property for, you have to use it as an investment property for like 2 years and then whatever? No, it's not like that. So basically, in order to continue to claim the tax benefit under Prop 19, you have to continuously use the property as the principal residence. If you can no longer file your homeowner's exemption for that year, you're going to lose that tax benefit. It's going to be reassessed. I guess that's where the use it or lose it thing is from. Neil Kalin wrote that in. He's a pretty funny guy. Anyway, so again, we know that a lot of these questions on Prop 19 are unclear. And there's just a general warning to stay away from providing tax advice to clients. However, what we do have at CAR is we have a series of information that we have a number of informational materials which can be used. This is a Q&A, but we also have a new website which is designed to provide kind of marketing materials, flyers which explain Prop 19. And also, I think even there's some social media advertisements which can be used to promote the benefits of Prop 19. And you can use all of this information. And the good part is without legal liability. So that's the point. Okay. And here's the site where you can find this on our website. Okay, so anyway, that's Prop 19. Now, I'm already, I guess, way behind schedule here. I'm sorry about that. As I was explaining to the other people, I'm combining basically 3 presentations into one here. So I'm really sort of short on time. I think I'm going to be able to make it, but I'm sort of like kind of rushing through things. Anyway, so one of the questions we get on CAR, when I say one of the questions we get on the CAR hotline, I should really say constantly we get this question. Like if I talk with 20 agents a day, I'm getting this question at least 5 times, if not 10 times. And this is basically, why is it so dang complicated terminating a tenancy in right now? So I'm going to explain this. And in order to understand this, you sort of have to go back in time. So if we go back 2 years ago, it was a simpler time back then. But one of the things that an agent, I think, could do was something that was within the scope of expertise of an agent, was to give basic advice to a client on how to simply terminate a month-to-month tenancy. Okay, well, that changed pretty dramatically in January of last year, and that's when you had the statewide rent cap and just cause eviction law. So starting January of last year, you had a law which basically said that you no longer could simply terminate a month-to-month tenancy on giving notice. No, if your property fell into the protections, then you could only terminate tenancy based on 11 specified fault reasons, or 5, now it's 5 no fault reasons. There were exemptions, however. There was an exemption for single family properties, condos, new construction. But guess what? In September of last year, those exemptions went away. So under the emergency or the temporary legislation, there's no exemption. So right now in California, it doesn't matter what kind of property you have, single family, condo, new construction, duplex, it's all subject to the statewide just cause eviction procedures, which, as I said, require one of 11 fault reasons or 5 no fault reasons. Okay, and then you have, on top of that, you have the CDC order. That's the federal. What does CDC mean? I'm not even sure. I can't remember. Anyway, you have the CDC order, and that is also basically creating a kind of rent moratorium. I'll talk about that just a little later. And on top of that, you have local moratorium, which can be even more restrictive than the state law. So let's look at these very quickly. This is a broad overview, and now I'm going to sort of look at it in just a little bit more detail. So which properties are subject to the just cause rules now? And as I said, all of them. Okay. In fact, there was an exemption for tenants who had been in a property for less than 12 months, no longer. So if a tenant has been in the property for more than 30 days, they're going to be subject to the just cause rules. And now that includes mobile homes as well. So that was previously excluded from the just cause rules. So all these are in just cause. And here are the 11 fault reasons. And here are the 5 no fault reasons. So oftentimes as an agent, let's say you have a listing of a single family property and there's a tenant, which of these, and let's say the tenant is a tenant in good standing. So you're not evicting this person because they're creating a nuisance or criminal activity, they're in good standing. You have to go with a no fault reason. Which of the no fault reasons is the owner really going to rely upon? Well, there's only 2 here. It's the second bullet point, withdrawing the property from the rental market. Okay, and that's dicey in terms of offering legal advice. So I think the owner can do it, but really, if that's what the owner wants to do, it's very straightforward. Talk with your attorney. Okay, and the last one is the other one, which is a possibility, but it's complicated. Look at it. When a seller is in contract to sell a single family property or condo, and the buyer intends to take occupancy, assuming the notice of exemption has been provided in the appropriate manner. So there's a lot of sort of technical things going on there. Here are the exemptions that are no longer case. So I wanted to just drop down really quickly to our termination notice. I'm going to go back. So here is our termination notice, which we have sort of specially prepared for these COVID times. And you'll notice this details each of the 5 no fault exemptions that I just had on my screen. And B is owner intends to withdraw the property from the rental market. E is the one where maybe you can use And it says, owner has entered in contract to sell the premises to a natural person, and the purchaser intends to reside in the premises, and title to the premises is separately in. Well, don't worry about that. That just means single family property. And there's a lot of ands here. And the owner has previously provided tenant with a single family property exemption, car form RCJC dated. So that exemption thing, how do you provide that? That's a little tricky. Basically, you have to have the tenant sign it and the landlord sign it. That's one way to do it. Or you have to change the terms of tenancy. It's month to month, and you can do this by saying by attaching it to the change in terms of tenancy form, and then delivering that in the same way you would deliver a 3-day notice to pay rent or quit. So what am I trying to say here? well, I'm trying to say basically that it's no longer so simple to terminate a tenancy. I mean, it's quite tricky. So clearly, you can't just simply deliver a 60-day notice, which is what a lot of the calls I get are. An agent has simply delivered the 60-day notice, or the landlord has, and they expect the tenant to vacate. Well, that's not working, right? And then at this point in the conversation, I always suggest to the agent, well, you know what? You may want to consider having the tenant vacate voluntarily through a cash for keys deal. And the fact is, we have a cash for keys form cash for keys, CFK. So basically, you might try to work out an agreement where the tenant vacates the property voluntarily, and that's something an agent can negotiate. Not in LA County if it's subject to the RSO. Don't do it then, but in most other circumstances, you can do it. And again, using the cash for keys deal, what if the tenant is behind on rent and the landlord doesn't want to pay this tenant to move out since they're already behind on rent? We have this other form. I can't read what it is. It's the C. Boy, this is embarrassing. Car form CRFP. So, basically in this one, you're not paying the tenant to move out, but you're getting the tenant to move out on the basis of having waived all of the past due rent. So maybe that's more palatable. But the point here is, you have to be aware of what is happening. So I find in talking to agents, not everyone is completely aware of what the contract is actually saying. So realize that when you're using the standard RPA form, that seller who is in contract is promising occupancy. Okay, the seller must deliver the property vacant. It's not a promise to make a good faith effort to get the tenant out. It's not dependent upon whether the tenant cooperates. No. It says, and this is all under paragraph 9 of the RPA, it says that the tenant will be out 5 days in advance of closing. Now, if you want to sell the property where you're not promising occupancy, there's a very simple way to do that. Check the box under paragraph 90. You'll check that box, subject to the tenancy. Tenant's going to stay in the property, and be sure to attach form TIP, the tenant in possession. So I just want people to be aware of what's happening. Okay, so let me go back. I skipped over a couple slides here, and I'm just going to do them really quickly, just to show you, because I know it's already complicated enough, but it really needs to be more complicated. And so you want to be aware that the CDC order is out there. It has just been extended either today or yesterday. It's just been extended to June 30th. It doesn't actually affect the eviction process until the very end, until the lockout. At least that's what the CDC says. And you may have heard in the news that some federal courts have overturned it. Well, those are district courts in other circuits, so they do not create what we would call binding precedent in California. So don't pay too much attention to that. And then you have places like LA County, which have their own rules, which are even more strict than the state just cause rental provision. You can't do any just cause eviction in LA County. So be aware of that. Now, LA County also says that due to the COVID emergency, its just cause eviction rules apply to cities within the county as well. That's kind of new. Normally, counties don't legislate within the city. The city is sort of an island within the county as far as the law is concerned, but the county of LA is saying, oh, these rules apply in the city because of our emergency powers. So you need to be careful there. And the bottom line, I guess, is I think you could negotiate a cash for keys, but honestly, you should be advising your own client to speak with an attorney when it comes to the dicey business of removing a tenant from a property. And I haven't even discussed the timeframes that are available in counties, which differ across the state, depending upon the courthouse. Okay, so let's see, where are we? Okay, and we're at 1 hour and 40 minutes. I think I can do SB 91 and the state rental assistance in the next 20 minutes. Yeah, sure. Okay, so this rent moratorium came into effect in California in September, and I sort of alluded to that before. I said that the just cause rules were extended to all properties in September, and that was through this law AB 3088. But in January, this law was extended. Okay, it was extended by SB 91, and now this California rent moratorium has been extended through June 30th. So before everyone was waiting for the January 31st date, because what it said is that tenants had to pay or could be forced to pay 25% of the rent due between September last year and January. They could be forced to pay 25% of that rent by the end of January 31st. But then SB 91 came along and said, no, we're going to extend this deadline. We're going to extend it to June 30th. So now all of that money, which was supposed to be gotten, is now pushed back to June 30th. By June 30th, under the current rule, the landlord has the possibility of demanding and receiving from the tenant 25% of the rent due between September of last year and June 30th of this year, on pain of being evicted through the unlawful detainer process. So, but it's very difficult to evict in general a tenant for non-payment of rent right now because of the rent moratorium. Now, the just cause eviction rules, which I have on the bottom bullet point, I've already gone over that in great detail, don't need to explain it. Part of SB 91 basically said that you had to have provided this notice to your tenant if that tenant was behind on rent as of February 1st. So this notice had to be provided by February 28th. If you're in that boat and you didn't provide the notice, then that could be a real problem if you're intending to evict on the basis of non-payment of rent. Here's a copy of the form. And how do you collect your rent then if you're owed all of this back due rent? Well, people have this idea, and I'm not saying it's a wrong idea, it's common sense, it makes sense. But the idea is that, well, I just wait until after June 30th, then I can demand all of this rent in a 3-day notice, pay rent or quit. No. This COVID rent, the rent owed between March of last year and June of this year, you are not going to be able to demand that rent as part of an unlawful detainer process. Not happening, except for the 25% between September and June 30th. So the question is, well, how do you collect it? And one answer is, well, you can collect it as a kind of personal debt in small claims court. So beginning August 1st, you can go to small claims court for any amount, regardless if it's over the regular small claims court limit. You will have to attach a declaration to your small claims court or even your normal civil court proceeding, stating that you made an effort to obtain rental assistance, or that the tenant, or that you cooperated with the tenant's effort to obtain such assistance. Okay, so that's what we're going to talk about now, I think. Yes, the state rental assistance program. Okay, so the state rental assistance program is really a program that was initiated by the federal government, and it's designed for the purpose of settling these rent arrearages that have come up in the last year across the country. There's this sort of fear of a deluge of evictions that are set to happen once the COVID protections cease. And when I say the COVID protections, for most of the country, or for a lot of the country, that's the CDC notice. So they passed this law, which is attempting to settle all of these debts before this sort of rental catastrophe happens. Well, in California, that was not going to happen anyway, because we have very restrictive rules, which make it very difficult to evict the tenant. But we're getting the benefit of the law nonetheless. So the federal government gave $1.5 billion to the state of California, and then gave an additional $1.2 billion distributed to cities and counties with populations over 200 million people. Now, I have in a yellow highlight an additional $21.55 billion, it's a very precise amount there, which was created as part of the most recent stimulus bill. And that's important because they run out of these funds, and I don't believe the $21.55 billion has yet to be distributed. Okay, so how does the state rental assistance work? Well, basically what it's saying is that it's going to prioritize households, eligible tenant households, whose AMI, that is average median income of the county, is 50% or less, or one of the eligible household tenants has been unemployed for 90 days or more. And that's the priority. Those are going, so everything's going to be given towards that type of eligible tenant in the first instance. And the second priority, it's given to rental arrearages. So there's other possibilities for utilities and future rent, but that's not happening now. And you might ask, well, is there a catch? And the answer is yes, there is a catch. If the landlord participates in this program, in most cases, the landlord will have to give up any further claim. First off, they're only going to get 80% of the rental arrearages, but then they have to give up the remaining 20%. So give up means they have to give up any claim in law, and they can't use that 20% as the basis for an unlawful tainer. So this is not so important, but basically if the program continues and there's enough funding, you can even get prospective rent yet to be paid, but that's limited to three months. This money, this 80%, is in fact paid directly to a landlord. That's the good news. Okay. Now, the applications for the state assistance program were started on March 15th, or at least they were supposed to, and actually they were started on March 16th. And there's all of these criteria that they've adopted to make sure the program is going smoothly, and it seems to be going smoothly. So that's also good news. It's not easy to get one of these programs started in short order, but they were able to do it. You might wonder, what is the average median income in Orange County? And I have it here. So let's see, I have a cursor. Can I use my cursor? Screen, pointer options, pen, laser. Okay, we'll go laser. Okay, so here we have Orange County, median income, and the 80% mark is this low income, and for a family of 4, so it varies depending upon the number of tenants, children included. For a family of 4, low income, 80% is 102. seems high for low income, but very low income is 64,000. That's actually the 50% mark. And these are rough numbers. These are not exact, okay? And then for a family of four, extremely low is going to be 830, and that's the 30% mark. And if you're interested, I have also included Placer and Plumas County as well, just in case you wanted to check it out. As a landlord, you might ask, well, what is it that I need when I apply? And the state of California has provided this handy dandy little checklist, which you can use, which will help you sort of get all of your documents and everything in order when you apply. So very useful little thing. And you might ask, where do I sign up for this? And I have the link there. And what the state of California is telling us is they're saying, this is a no wrong door application, meaning when you apply, if you apply in the wrong jurisdiction, or you're going to be directed to the correct place to apply. So you only need to go to this site, and if you have to go to a different site, it will direct you to go there. But you can also check out your locality anyway. So I've been talking about the state rental assistance, but the tricky part is that not everyone is going to receive the rental assistance through the state website. There's actually 3 different possibilities. Okay, so if we look at these 3 possibilities, and this is important because you'll see why. So if we look at option A, so option A is all counties with populations under 200,000 and the cities within them. So those are going to be directly administered by the state of California. You just go to the state website and that's where you apply. Now there's other cities, these cities and counties, city of Fontana, any in Orange County, I don't see them. These are cities and counties with 200,000 people or more. And what these cities said is, look, we got all this money from the federal government, but you know what? We're not really interested in doing all of the hard work of setting up in an IT infrastructure and administering this program. You know what? We're just going to hand it over to the state of California. Let them do it, since they're already set up. And in my mind, that makes a lot of sense. Like if I worked at a city, in a city government or the county, that's exactly what I would do. It's like, I want to sleep in on the weekends. Why am I bothering replicating all of the things that the state of California is already doing? I'm just going to hand all of my money over to the state of California and let them do it. And that's what these cities are doing. But what about option B? Okay, and we notice under option B, there's a couple things that we might look at. I think there's the city of Irvine is there under option B, and so is the city of Anaheim. So what's happening under option B? Well, option B, again, these are localities that have a population of 200,000 or more. They've received the money directly from the federal government. And on top of that, they've agreed to abide by all of the state rules in administering this program. And because of that, the state of California has handed them all of this money, this quote, block grant. The point here is that the people under option B, the counties or cities under option B, they're administering their own program. So if you were to go to the state website and you're in one of the option B, you would be directed toward that site. Now, what about option C? So option C, again, these are cities and counties with populations above 200,000. And we see there, Orange County is among option C as well. And also, I think the city of Santa Ana, right? So what's happening in option C is that they've received the money from the federal government, but they don't want to follow the rules of the state of California. They're saying, no, we're not going to do that. We have our own idea of the best way to implement this program. Now, it's true we're bound by the federal rules, but we don't like the state rules, so we're going to implement the program on our own terms. Okay. Well, that means they're only implementing the money they received from the federal government. What about the block grant money that they were supposed to get from California? Well, California is going to implement that in their jurisdiction, but through the state website. So there's going to be two, not competing sites. And that's going to make things a little bit more complicated. You may have to apply in two different places. It's going to slow down the application process. The state of California says that they're not going to release any money until there's sort of a cooperative agreement worked out. So option C is definitely the more complicated of all of the three options. And I have here, so I previously gave you the chart showing the average median income for Orange County. And here I went to the Anaheim site. And if you recall, where is Anaheim? What's Anaheim? Anaheim is option B. So option B, so Anaheim's running its own program. And look what it says here. It says, now in a second phase of the program, we're offering help paying off rent and utility bill debt from April. So they're in the quote second phase. I'm not sure if that means they've received the money through the second stimulus, but the point is they're still open for business. They're administering the program on their own terms, and you can apply. Oh, by the way, I've done this extra work of finding special slides, creating special slides just for Orange County. I did that just because it's Orange County. I wouldn't have done that for anybody else, but because it's Orange County, I did that. So, and then I went to the Orange County site, and I did not like reading this, honestly. And frankly, I'm a little confused. Now, I told you, I think Orange County, as I pointed out, is an option C. And I told you before that things are a little bit confused with option C. It's trickier. And here it says, the County of Orange closed the application period for the Emergency Rental Assistance Program on February 28th, 2021. Well, that was weird because in another thing I read, they had opened it on February 28th, 2021. They opened it and closed it on the same day. I mean, I don't know what's going on there, honestly. But you have to keep your eye out for Orange County because obviously they're going to, I don't believe they've completely, have completely doled out all of the money in that one day. Irvine is also an option C, and something sort of weird went on there as well. They opened up on March 15th, but then they closed within 5 days. So all of the money for Orange County was gone, but I think there's still going to be a second stimulus. They still have yet to do the second stimulus. So common questions we get on the about the state rental assistance, and I'll just read through them. So if a former tenant owes rent, can it be collected through the state rental assistance program? And the answer is no. It's designed to keep current tenants in their property. If the tenant is vacated, then no dice. If a tenant is Section 8 hasn't paid their portion, can this be paid through the state rental assistance? The answer is yes. Because if the tenant is having problems paying their portion, they should really be recertifying with the Section 8 program. Do rental arrears include parking and storage? And the answer is the state of California, at least, isn't going to delve into the concept of rent and try to pick apart what's included in that. If it's rent that's being paid, then they're going to cover it. And can a property manager assist in completing the application? And the answer is yes, but the landlord will have to add them as a designee, once they input their information on the state website. And here's the second to last bullet point is a very, very big question. Will I need the tenant to cooperate in the application process? And the answer is absolutely. It's a joint effort. You're not going to be able to do this on your own. It's going to require both the tenant and the landlord. And finally, this is a question, this is an option C question. My county city has opted out of the state program altogether. When can I apply? And so the answer there is even if the locality is opted out, you can apply through the state on March 15th. At least that's what the state of California said you could do. But they're not going to process that application until the two programs are coordinated. Okay, so I think that's it. I got in under 2 minutes. Pretty good, huh? Anyway, I can try to take some of the questions I see, but let's see if I'll just try to read through any of these questions here. This law. So some of the tax questions are kind of tricky. Does the law allow transfers from spouse to spouse while the first one's still alive without the reassessment? There's actually a slew of different types of what we would call exemptions from reassessment. There's like a list of 10, 15 of these things. And I think a spouse to spouse transfer is one of them, but don't quote me. And I mean, really, this kind of tax question just has to be referred to a tax expert. How long does the child have to live in the home? Basically forever. You can't stop living in the home. If you do, and use it as a principal residence, if you do, then you're no longer going to be eligible for that tax savings. Let's see, under Prop 19, can a 54-year-old purchase a home after April 1st and then sell their primary residence 1 year later? I'm not sure on that question. There's a lot of, I know that I'm positive that you can't sell the home before you turn 55, but I don't know whether you can purchase it. So I'm going to defer on that one. Can the replacement purchase be made before the sale of the primary residence? Yes. So the purchase can occur 2 years before the sale or 2 years after. And I want to refurbish my condo. I want to refurbish and sell my condo. I want to give 60 days notice to move while the tenant is paying the rent. Is that allowed? Okay, so one of the 5 fault reasons, I'm sorry, one of the 5 no fault reasons was substantial rehabilitation. And that is a very difficult criteria to meet. That's a very difficult reason to meet. When they say substantial, they mean it. It has to be really big. It has to be such that the tenant has to vacate for a full 30 days. And on top of that, they limited it further now. It has to be for a habitability problem within the unit. So the answer is almost certainly going to be no. But I guess if you had a very, very specific and specialized case, it could be a yes. Will it be considered, what is considered withdrawal from the rental market? Well, that's an interesting question. It's a tricky question. In my mind, I'm selling the property and I could not be any more emphatic that I'm withdrawing it from the rental market. I mean, how can I make my intent to withdraw it from the rental market any clearer than I'm selling it? That is how badly I want to get out of the rental business. So in my mind, there's not an issue here, but apparently some of the landlord-tenant attorneys have an issue with that, and they don't know if it's actually going to be viable as a basis for eviction. I think it should be, but this is where you really have to speak with a particular landlord-tenant attorney in a particular jurisdiction. So that's why I tell you to stay away from that. And can landlords use the fact that you did not pay all of your rent during the moratorium as a reason not to renew the lease after June 30th? Okay, I did not cover this question. I cut down the presentation on the basis of time. But the fact is, part of SB 91 says, no, you cannot do that. SB 91 says you cannot use unpaid COVID rent as a basis to refuse a tenant applicant. And I would assume that also applies as a basis for refusing them to remain in the property. It's a protected, quote unquote, source of income criteria. Okay, does the state rental program apply to commercial properties? No, it does not. What if a tenant has a new lease because they were evicted because of a UD at a prior place, but are still being affected? Can they get assistance? I don't think that's part of the criteria. The assistance, yeah, so the criteria is based upon various types of household eligibility income and whether they've been employed. I did not see that as a criteria, so I would say that's not a factor. And so I'm going to send this out to Lisa Yi, and she will provide the presentation to everyone. And finally, if my sellers have a tenant who has not paid rent since January 2021, if their rental agreement ends May 31st, what options does the landlord have legally? Okay, so I didn't cover this one. I sort of blew past it, but I want to make a point here, which is you have a tenant, and that tenant is on a lease, and the lease expires in April or May, doesn't matter. That is not a basis for evicting a tenant under the just cause rules. So let me say that again. The lease is expiring. That is not a fault reason or even a no fault reason for terminating a tenancy. It seems like it should be, but it's not. So if that's why you want to terminate, it's a lot more complicated than that. You have to give the tenant the option of renewing the lease on like terms and like duration, and only if the tenant rejects that option would that be a basis for terminating a tenancy, and that would be a fault reason. Okay, so don't make that mistake. Okay, I think we're good.
Robert, thank you for taking the time to explain this to us. This is some very complicated issues, and you really broke it down very well on all three subjects, and I think we're coming away with a better understanding. So thank you for your time and coming out here. And once again, everyone, thanks for joining us. We'll let you know when our next meeting will be, and appreciate you joining us online for this.
All right, and I want to thank you for inviting me. It was a pleasure. I'm glad to be back in Orange County, even though I'm not technically in Orange County, but yay.
Thank you so much for the presentation. And I just want to remind everybody this presentation had been recorded and also will be shared on the Orange County Realtors Facebook page. And the slide will be sent to those who RSVP for this event. And if you have any specific question, welcome to call the CAR legal hotline to find out more information about your specific case.
Okay,
and thank you for everybody to join us today, and we'll see you for our next event.